I appear on behalf of the applicant, as well as accused 5, 10, 12, 13, 5, 10, 12, 13, and 14. Accused 10, of course, is the applicant who brought the application for recusal. May it please the court.
As the court pleases. My lord, I am here as an observer, as already indicated previously, for 8, 9, and 10, as well as 23, 24, 25, 26, 27, and 28. As the court pleases.
Yes.
Please, my lord, I and Mr. Lutwez appear for the first respondent in this matter. Yes. And while still on my feet, my lord, I've been given a medical certificate for accused number 1, Ricardo Gustavo. That he is admitted at hospital, my lord. If I may tender the same, my lord.
Yes, but if it's not a problem, how long is he admitted for?
Unfortunately, it's not indicated. It simply says he has been admitted on the 10th of March 2024 for immediate treatments. He remains admitted, undergoing further investigations and treatment. No duration for the detention has been indicated, my lord, or when is likely to be discharged.
Today is just judgment taking, isn't it?
That's correct, my lord.
Now, for the accused persons who are not represented,
Respondent number 3.
yes.
And also representing respondent 17, 18, 19, 20, and 22nd.
Yes. Who's next?
Myself, Shangala, representing also 21.
Yes. Yes.
Bernard Martin Yeso. My lord, in the absence of my legal counsel, I represent myself, accused respondent number 5, and respondent 24. Thank you.
Yes. Has everyone been covered?
Worship, accused number 6, Pius Matlanoe, appearing in person, Bristol. 7th respondent, and I also appear for respondent number 15 and 16.
Anyone else?
No.
Unrepresented?
Pardon?
I'm asking whether there's anyone else who is unrepresented. So today is the day I sat down for handing down my judgment in the recusal application. My judgment is ready, but I understand that there will be, it will have to be formatted. I don't know how long that will take. So because of that, I will read my judgment, and when it is available, after the necessary formatting, then I'm sure it will be made available to the parties. It's a fairly long judgment, so you'll have to bear with me. Right. This is an application for my recusal by 1 individuals and 18 corporate entities charged with criminal offenses arising from events that took place between 2011 and 2019 after an Icelandic company, Sam Harry HF, entered the Namibian fishing industry. The applicant, Nigel van Wyk, is the 10th of the accused persons. The charges against the accused persons mainly revolve the allocation of fishing quotas, the disbursement of proceeds from such allocation, and alleged misappropriations of payments made by beneficiaries of the allocated fishing quotas. The criminal trial was due to start on 2 October 2023 pursuant to an order of Miller AJ dated 14 February 2023, paragraph 3 of which reads, and I quote, "The matter is set down for trial on the following dates: 2 October 2023 to 13 October 2023, 30th October 2023 to 10 November 2023, 27 November to 8 December 2023, 29 January to 9 February 2024, to 9 March 2024, 13 May 2024 to 31 May 2024, 17 June 2024 to 28 June 2024. It is to be noted that when the above order was made, all accused persons were legally represented. On 14 August, the matter was postponed to 20 September 2023 for final pre-trial hearing on the understanding that the matter will proceed in October 2023. I was first seized of this matter on 20 September 2023 after my appointment as acting judge of the High Court of Namibia. At that hearing, I was constrained to make an order postponing the matter to 13 October 2023 for status hearing to address issues raised on that date, in particular issues relating to the legal representation, legal aid applications and their outcome, and the Section 26 POCA applications. All the accused were legally represented. On 13 October, I again postponed the matter to 23 November 2023 to give an opportunity to the parties to finalize outstanding issues. All the accused were legally represented except accused 1 and the entity that he represents, that is accused number 11. I postponed the matter to 5 December for commencement of trial by taking pleas, and I ordered the state to facilitate a request by accused persons who wished to undertake research on their own. This last order applied particularly to accused 1, who is acting in person and had requested for access to Wi-Fi and his laptop. Again, except for accused 1, all the accused were legally represented. It was this order that, and the sequel thereto, that gave rise to the present application for my recusal. The accused persons, one or other or all of them, are, generally speaking, charged jointly and severally or with common purpose under various statutes read together with the Criminal Procedure Act. Number 51, 1977, number 51 of 1977, I will refer to it as the CPA. They are charged of racketeering, money laundering, possession or use of proceeds of unlawful activities and other offenses under the Prevention of Organized Crime Act 2004, number 29 of 2004, which I will refer to as POCA. Corruption, conspiracy, and other offenses under the Anti-Corruption Act 2003, number 8 of 2003, which I will refer to as ACA. fraud, alternatively theft, tax evasion, and failure to furnish tax returns under the Income Tax Act 1981, number 24 of 1981, conspiracy to commit fraud, tax or a tax evasion under the Riotous Assemblies Act 1956, number 17 of 1956, defeating or obstructing or attempting to defeat or obstruct the course of justice, unlawful possession of ammunition under the Arms and Ammunition Act 1996, number 7 of 1996, assaulting, resisting, or obstructing an authorized officer under ACA, and resisting a member of the police under the Police Act 1990, number 19 of 1990. The main or most serious charges are under POCA and the Anti-Corruption Act, read with provisions of the Criminal Procedure Act. Several of the main charges, about 42 of them, have alternative charges. POCA was enacted, among other things, to introduce measures to combat organized crime, money laundering, and gang activities, to prohibit certain activities relating to racketeering activities and money laundering, to recover proceeds of unlawful activities and forfeit assets used to commit crimes or assets that are proceeds of unlawful activities. The Anti-Corruption Act was enacted to establish an anti-corruption commission and for the prevention and punishment of corruption and matters incidental thereto. The applicant is charged, I'm narrowing down on the applicant alone, is charged on 9 counts as follows. Count 1 and 2, together with all other accused of racketeering in contravention of specified provisions of POCA, as read with the specified provisions of the Criminal Procedure Act. Count 4, together with all other accused, money laundering in contravention of specified provisions of POCA, as read with the specified provisions of the CPA. Alternatively, money laundering in contravention of Section 5 of POCA, as read with other specified provisions thereof and provisions of the Criminal Procedure Act. Count 12, unlawful possession of ammunition in contravention of specified sections of the Arms and Ammunition Act. Count 13, together with accused 3, defeating or obstructing or attempting to defeat or obstruct the course of justice. Count 14, assault, resist, or obstruct an authorized officer in contravention of specified provisions of the Anti-Corruption Act. Alternatively, assault on a member of the police in contravention of specified provisions of the Police Act. Further, alternatively, resisting a member of the police in contravention of specified provisions of the Police Act. Count 39, together with accused 1, 5, 6, 8, 9, 11 to 28, contravening specified provisions of the Anti-Corruption Act, as read with specified provisions of the Criminal Procedure Act, by conspiring with accused 2, 3, 4, and 7 to commit the offense of contravening certain specified provisions of the Anti-Corruption Act. Count 40, together with all the other accused, is charged with theft as read with specified provisions of the Criminal Procedure Act. And count 41, together with all the other accused, is charged with money laundering in contravention of specified provisions of POCA as read with specified provisions of the Criminal Procedure Act. I deal now with the service of the recusal application and the response thereto. The recusal application was served on all accused persons in the state. They were cited as respondents in the application. Hereinafter, I refer to all of them except the state as accused persons. Only the state has opposed the recusal application. The other accused persons have not opposed the application, nor have they made any indication that they support it. If indeed they supported the application, it is expected of them to have filed some document associating themselves with it. As at some point during the plea proceedings on 8 December 2023, accused 4 intimated that he was going to make an application, a similar application for my recusal, but for some reason, he has not made common cause with the applicant. Accused 3 stated that he was not served with the state's notice of opposition and answering affidavit. and as such, he was not aware until the hearing date that the state was opposing the recusal application. He left it to inference that what his position was with respect to the issue he raised. All I can say is that ideally, the state should have served the answering affidavit on all the respondents. That it failed to do so, it seems to me, was because the respondents had to associate themselves with the application. The genesis of the recusal application in greater detail. The applicant and his co-accused were arrested in 2019. They have been in custody pending trial since then, a period of just over 4 years. Fortunately for the applicant, he was granted bail just before my order of 5 December 2023 and is therefore out of custody. As earlier stated, a timetable had been agreed upon as to when the trial would commence and the dates on which it would continue. At the first hearing of the matter on 20 September 2023, all accused persons, as I earlier said, were legally represented. The practitioners who appeared were Mr. T.B. Brokenoff for accused 1 and 11, Mr. Mrowa for accused 2, 3, 6, and 15 to 22, Mr. F. Bucas, represented there by Lina Shikongo, for accused 4 and 24, Mr. M.C. Siomunji for accused 5, 10, 11, 13, and 14, and Mr. Engelbrecht for accused 7, 8, 9, 23, 25, 26, 27, and 28. Warning signs that the trial was not likely to commence or continue as agreed to before my arrival appeared on the first day. Mr. Marondeze for the state advised the court that the state was ready to commence the trial with local witnesses only. He pointed out to a number of issues that militated against a commencement of the trial on 2 October 2023. The state had not yet subpoenaed foreign witnesses, the cost of which, in his words, are heavy. It needed assurance from defense lawyers that the trial would in fact start. It needed one or other of defense lawyers wished to lodge applications in terms of Section 26 of POCA on behalf of their clients to access funds from their savings and other assets which are currently under a restraining order at the instance of the state. Other legal practitioners were in the process of assisting their clients to have the legal costs paid by the state because at the time of their arrest, they were serving members of the executive or state employees. Others had already applied or were going to apply for legal aid from the Directorate of Legal Aid or were awaiting responses, as the case may be. He advised that he and counsel for all accused persons were of the common position that the trial should start on 29 January 2024. He also advised that the indictment and the pre-trial memorandum had been filed and served as of 22 April 2021. The state had made necessary disclosure to the accused persons. The most significant warning sign given by Mr. Marondeze was that the accused's legal representatives, and I quote, say that they have not started reading for the case because they have not been placed in funds. The state is aware of the size of the documents, he said. These representations by State Counsel did not really convince that the state was ready to commence trial as it purported. The accused's legal representatives, each in his own way and in varying detail, endorsed what Mr. Marondeze said. They all agreed with the proposal that a status hearing be held on 13 October 2023. When the court convened on 13 October, the issues raised by Mr. Marondeze and Defense Counsel remained unresolved. I agreed, as requested by the parties, to another status hearing on 23 November 2023. On that date, that is 23 November 2023, I indicated to the parties that it was time to commence the trial by taking accused pleas during the week beginning 4 December 2023. Mr. Marondeze said that the state was ready for plea entry and to proceed to trial, provided that it was given 14 days to summon its witnesses. According to him, that meant the trial could only commence on 14 December 2023. Mr. Mroura said he had represented his clients from inception. He advised that an application in terms of Section 26 of POCA had been filed on his client's behalf during the first week of November 2023. He anticipated that a notice of opposition was to be filed the following week and answering affidavits in January 2024. A hearing of the POCA applications would, in his estimation, be in April 2024 at the very earliest. Representations had been made to the Attorney General for the state to meet accused 3's legal costs. An application for legal aid had been made on behalf of accused number 6. He estimated that the trial could only commence in June 2024 after the applications lodged with the court and other authorities would hopefully have been finalized in the accused person's favor. He was not ready to proceed with the trial until the funding issues were resolved. I understood him to be saying that insofar as he was concerned, he was not prepared to go ahead with the trial unless he was assured of his fees, that his fees would be paid. Mr. Pukas said that he had represented accused 4 and 5 since 2020. He stated that accused 4 had applied for legal aid and written a letter to the Attorney General for legal assistance. He had also filed an application in terms of Section 26 of POCA. Mr. Siomunji stated that legal aid had been secured for the applicant, that is accused 10, but he was not ready to enter a plea in the week beginning 4 December 2023. Accused 1 related the history of his arrest in brief, covering the initial admission to bail and his re-incarceration after the bail was cancelled on appeal. He had applied for legal aid on 10 August 2023 and had not received a response. His application in terms of Section 26 of POCA had been resisted by the state and he had resolved to represent himself. Plea taking in the week beginning 4 December 2023 was a bit tight, to use his own words, for him. He needed time to prepare himself. Mr. Engelbrecht stated that he and his clients were ready for trial and had opted not to respond to the state's pre-trial memorandum. I considered that the accused person had been in custody for far too long before their trial commenced. Having heard them on the various issues they raised, I was not persuaded that those issues could be resolved within a reasonably short time, and I was satisfied that it was necessary to make a start by at least proceeding to plea entry. At the hearings before me on 20 September and 23 November 2023, all the accused were with their legal representatives. The main issue was continued legal representation in the absence for some of the accused of funds to pay the legal representatives and the refusal by the Directorate of Legal Aid to extend legal assistance to some of them. All this boils down to one thing, that some of the accused are unable to secure legal representation for themselves for one reason or another. When I asked of counsel this question, Mr. Bukas appreciated that if funds cannot be found, the accused have to represent himself. Ultimately, the state's position was that it had been ready to commence trial from the time it served the indictment in October 2021, subject to reasonable notice to enable it to subpoena its witnesses. 3 individuals and 5 corporate entities represented by Mr. Engelbrecht were ready for trial. Accused 1, now acting for himself, was also prepared to proceed to trial. I considered the timetable previously set with the apparent agreement of the accused persons and their legal representatives for the trial to commence and continue, and the ensemble of lawyers at the hearing on 20 September and 23 November 2023 in reaching the decision to commence the trial by plea taking. I did not foresee or anticipate that the absence of assurance of readily available funds to pay lawyers' fees would result in some of the lawyers pulling out or those remaining putting spanners in the works so as to delay the proceedings until they received assurances they sought. I did not anticipate that the legal representation issue would become intractable and seemingly interminable. Little did I appreciate that the sword of Damocles, constituted by the threat by lawyers that if they are not put in funds, they would withdraw from the trial, would strike sooner rather than later. I consider that the plea entry would commence on 5 December with the accused persons being required to plead to the charges only. I indicated quite clearly that after the pleas, the court would consider whatever other concerns the parties might have. Now, the hearing on 5 and 8 December 2023. When the case was called on 5 December for plea taking, there was a spirited resistance to taking pleas by some of the accused persons in relation to themselves and on behalf of the entities they represented. Accused 2, 3, and 6 and the 8 entities they represented were no longer legally represented by Mr. Mroura, he having renounced the agency on 4 December 2023. Accused 1, as previously stated, was acting for himself. Accused 3 stated that he was unable to plead and complained, among other things, that he was no longer legally represented. The restraint orders under POCA had made him a pauper in circumstances where his legal representative charged $65,000 per day, and that he should be released from custody. Accused 2 echoed the same sentiments as accused 3. Accused 1 said that while he intended to proceed with the trial, he wanted access to Wi-Fi and his laptop to prepare himself. He also said he should be released on bail. Accused 7 as well asked to be released on bail. They all wanted the plea taking to be postponed to a later date when their legal representation was in place. Mr. Bukas was ready for plea taking but not opposed to a postponement sought by the unrepresented accused persons. He stood for Mr. Siomunji. He indicated that the latter's clients would be ready to plead except accused 10, the applicant herein, who had lodged a review application in relation to charges to the charges on count 1, 2, 3, 4, 38, 39, 40, and 41. Mr. Engelbrecht was also not opposed to a postponement and proposed 16 January 2024 for another status hearing. He, however, indicated that his clients would suffer prejudice if the trial did not commence within a reasonable time in all the circumstances. The state responded to the accused person's complaint or intimation that they should be released on bail. Mr. Marondeze stated that the accused could only be released on bail if they could show changed circumstances that would warrant a reconsideration of bail. I have described as in course a complaint the request to be admitted to bail because the accused did not mount an application in the true sense of doing so. They brought up the issue in resistance to the order I had already made that they were to plead to the charges. The order stood. It also was open to them to lodge a proper application for bail and not simply complain about their being in custody and expressing a desire to be released. Mr. Marondeze went on to outline the brief history of the matter and pointed out that while he appreciated that the matter was a complex one and that the documentation involved was voluminous, the accused had adequate time to prepare for trial. Disclosure of the docket had been made as far back as April 2021. The joinder of cases was granted in October 2021, from which date the state had been ready for trial. Accused persons had made several applications to the courts, and the withdrawal by some legal representatives had been made at the 11th hour. He submitted that the spanners, and I quote, that spanners are thrown into the state case by accused persons, and that should not be allowed. The state was ready to take pleas, he said. The accused persons, in particular accused 3, submitted in response that their fair trial rights would not be observed if the plea entry proceeded. He had outstanding invoices with his erstwhile legal representative. The whole process had been protracted. His estate had been frozen, and he had referred the matter to court in February 2021. Then came the joint application. Further disclosure continued in 2023, he said, and it remains incomplete. The docket provided to the accused was meant for one person only, and that they had not analyzed it. Certain persons who are to be charged together with them had not been extradited from a foreign country, and for him the question remained unanswered whether unrepresented persons could be tried fairly in the circumstances. Accused 1 protested that the trial outcome was, to his mind, a foregone conclusion, and he sought assurances from me that that was not so. I postponed the matter to 5 December, on 5 December to the following day, in partial accession to the request for a postponement. On that day, that is 6 December 2023, Mr. Siomunji and Mr. Bukas were not in attendance. The former for a reason I shall deal with later, and the latter because he had been taken ill and would only be available on 8 December 2023. Their clients, accused 4, 5, and 10, stated that they could not proceed in the absence of their legal representatives. Mr. Marondezi acceded to a further postponement, accepting that a postponement was justified because of the reported illness of Mr. Bukas. Mr. Engelbrecht proposed that the matter should be postponed to 30 and 31 January 2024. I postponed the matter to 8 December when, on the indications, Mr. Bukas would be back. At the commencement of the proceedings on 8 December, Mr. Bukas was not in attendance. Mr. Siomunji advised that Mr. Bukas was booked off sick from 6 to 22 December 2023. This was confirmed by accused 4 who handed in a sick note from a medical doctor. Accused 3 indicated that he wanted to make an application in terms of section 319 subsection 1 of the Criminal Procedure Act. In response to accused 3, I stated that the court was to, and I quote, proceed step by step and continue with the plea taking, and I would entertain applications of any nature after the plea taking. Following upon my ruling, the plea taking continued until pleas had been entered for all accused persons on count 1 to 4. I then adjourned the proceedings to 13 December for continuation. On 13 December, Mr. Siomunji advised that his client's application for recusal had been lodged and submitted that the proceedings could not proceed on account of that application. After a brief exchange with counsel and the accused persons, I issued an order setting the timelines for filing outstanding pleadings in the recusal application and set the hearing date for 1 March 2024. After my order, accused 3 raised a number of issues largely of an administrative nature, which I declined to deal with in light of the recusal application. The above summary of events, in my view, resulted in the present application. What clearly emerges from the summary is that although the accused persons have been in custody since 2019, there has been little traction in regard to the trial. The conundrum is essentially legal representation. The accused persons' assets are under a restraining order. According to them, they are not in a position to pay for legal representation of their choice. They would want to have their assets, or at least some of them, released to enable them to pay lawyers of choice. Some of them contend that as former members of the executive branch of government, they are entitled to payment by government for of their legal fees. Hence, those so concerned have approached the Attorney General in that regard, but with no satisfaction to date. Some of the accused have applied for legal aid from the Directorate of Legal Aid and have not been successful because they failed to meet the means test as applied by the Directorate. Some lawyers who have in the past or are still representing the accused persons or are willing to represent the accused persons cannot commit themselves because there is no assurance that their fees will be paid. In my view, the issues raised by the accused in regard to legal representation attract some sympathy because they are not entirely unreasonable. The accused have not applied directly to seek some other relief as may be available from the court, based solely on the understanding that they are facing serious and complex charges, and that the interests of justice may require that they be afforded a remedy. If they are not registering or anticipating success with respect to the Section 26 POCA applications, approaches to the Attorney General and the Legal Aid Directorate, I would have thought that they would apply to the court for it to exercise its inherent discretion based on the interests of justice in this case, quite apart, of course, from the issues they have raised in their POCA and the Legal Directorate applications and approaches to the Attorney General. It is quite possible that, faced with a submission that the interests of justice and its administration will be assured if the accused persons in this complex matter are legally represented, a court may very well exercise its discretion and order that the state should meet their legal representatives' fees at the scale applied by the Directorate of Legal Aid. The possible efficacy of such an approach to the court, I believe, is not lost to accused legal representatives or those legal practitioners who would otherwise represent them but for the absence of any assurance that fees would be paid. It seems to me that the accused and legal practitioners might be avoiding the approach for a reason. Either their legal representatives are not willing to work on a pro deo basis and be paid on the scale I have mentioned, or the accused themselves are seeking to apply pressure on the authorities and the court based on the stance they have that they are unable to pay their lawyers of choice because of the restraining orders. The critical question is whether, if the accused are unable to pay their legal representatives because their assets are under a restraining order, or the state, through the Attorney General, has not responded positively to the request for assistance, or the Directorate of Legal Aid has decreed that they do not meet the means test, or their lawyers will not act for them until they are assured of payment of fees, the trial may not commence at all, even if it means that the accused act for themselves. Whichever way it might be, the bottom line is that where an accused is unable to raise funds for his defense for whatever reason, his trial must at some point proceed with him representing himself. In this case, it has been a long 4 years and more before the accused are brought to trial. That cannot be in their interest, or in the public interest, or in the interest of the fair administration of justice. Nor can I say that an injustice may not result in the trial from a failure to provide legal representation for some of the accused persons. I am fortified in what I have said in this and the preceding paragraphs by Bernard Becking and Mildred Becking, who argue very strongly that the right to legal aid and legal representation is a fundamental right in any legal system that prides itself of being equitable, fair, and democratic, and must be afforded by the state to accused persons in a case which, in the opinion of the court, a substantial injustice would otherwise result. The learned authors considered the import of sections of the Constitution of South Africa, sections 7, 28, 34, and 35, which in substance are in pari materia with Articles 10 and 12 of the Namibian Constitution, which deal with equality before the law and the right to fair trial. Now, I deal with the recusal application and the submissions made thereon. The applicant was represented by Mr. Makondange at the hearing of this application, and not Mr. Siomunji, who had prepared the founding affidavit and the written submissions for the applicant. Before me, Mr. Makondange stated that he was standing by the heads of argument filed of record and did not intend to make any oral submissions. I sought to canvass with him certain issues of fact in the founding affidavit. His response was that he was not familiar with the contents of the affidavit and would not be helpful to the court in regard to the factual allegations made therein. He was aware that the applicant had not filed a replying affidavit, and so when I put it to him that factual allegations disputed by a respondent and not addressed by the applicant in a reply are to be construed in favor of the respondent. He readily conceded. An example of his unfamiliarity with the applicant's case is when I asked him how many charges the applicant faced. He said that he did not know. His response was all the more surprising because paragraph 1 of the heads of argument discloses those charges. What it showed me is that Mr. Makondange had not read the founding affidavit or the written submissions by which he was standing. He stated that he was not in a position to answer any question arising from the pleadings. I also asked him whether the applicant was speaking for other accused persons whose rights the applicant alleges to have been violated. He answered in the negative and stated that the applicant was speaking only for himself. I became convinced that Mr. Makondange was of no assistance in the application at hand, and I moved on. I called upon Mr. Marondeze to make his submissions. When he began to do so, accused number 3 stood up and said that my appointment to the bench was invalid and that he had written to the state president about it, demanding that the action be taken as would ensure that I did not continue to sit, or else he was going to sue the president. I asked him if he was making a formal application before me on the alleged invalidity of my appointment, and if so, what relief he was seeking in that regard. He was not certain and asked for more time to consider the matter. I also asked not be resolved by a response from the state president or by a favorable decision in the present application. He was not entirely clear in his response. He also complained that he had not been served with the state opposing papers, a matter which Mr. Marondeze later dealt with in his oral submissions. The application for my recusal is under the rubric bias and founded on an allegation that I am or might be biased. It must be observed that in setting out the facts tending to support the allegation, the applicant does not confine himself to facts and events that pertain to him alone, but to other accused persons who, although served with the application and the applicant's heads of argument, did not associate themselves with the application by, for example, filing a pleading or otherwise indicating that they support the application. They remained mum and non-committal. In the long introductory part of the founding affidavit, the applicant states, and I quote, I have always maintained that I am not guilty in this matter, and never have I admitted I have committed any act or omission constituting the offenses that I have been charged with. Suffice it to say that I am disputing all the elements of the charges, calling on the state to prove each and every element thereof. Such a statement is made by a person who, it is reasonable to assume, will plead not guilty when called upon to plead to the charges. The factual allegations in the application are presented in bullet point form. First, that on 5 December, his legal representative, Mr. Siomunji, informed me in chambers that he had to travel out of town on agency and sought permission to do so. I granted him the permission, it is said, but then I decided to continue with the plea taking on the following day in Mr. Siomunji's absence, with the result that the applicant and accused 5 were unrepresented on that day. Second, that in respect of some of the other accused who asked for an opportunity to have their legal representatives present, the learned judge pressed on with requiring them to plead, I was quoting him, ignoring the fact that the absence of their legal representatives was due to the fact that their applications for funding had not yet been decided, and stating that the accused had had sufficient time, and that I stated that the accused had had sufficient time to prepare for trial. He averred that I ignored their request for postponement for securing funds and for legal representation. Third, that on 8 December 2023, accused 3 gave notice that he intended to bring an application in terms of section 319 of CPA, and I disallowed him, stating that he had to do so after the taking of pleas. This despite that the essence of a 316 application directly affects the pleas that I was, and I quote, I was hell-bent on taking. Fourth, on 8 December, accused 4 presented a medical report certifying that his lawyer, Mr. Bukas, was off sick until 22 December 2023, and I carried on with taking pleas in circumstances where the said accused had not waived their right to legal representation. In addition, applicant's legal representative, Mr. Musyomunji, informed me, and I quote, informed me that procedurally the matter should be postponed until Mr. Bukas ignored the request and continued with plea taking. Fifth, that on 8 December 2023, accused 4 informed me that he was going to apply for my recusal, and I ignored him after Mr. Musyomunji again informed me that once a notice of recusal has been given, it is imperative for me to hold the proceedings and prepare to hear the recusal application, because it is an interlocutory application which holds the main trial until its finalization. I am accused that I ignored the advice given to me by an officer of the court and decided to go on with plea taking. Sixth, that on 8 December, I forced the applicant to plead to count 1, despite that he told me that he had filed a review application in relation to counts 1, 2, 3, 4, 38, 39, 40, and 41, and was unable to plead. I entered a plea of not guilt on his behalf, and that constituted a grave irregularity and a serious violation of his right to a fair trial as envisaged in Article 12 of the Namibian Constitution. The review application he averred implies that if successful, he would not be required to plead to the charges he is facing. Seventh, which consists entirely of a summary or is largely a repetition of preceding factual vehemence, that I violated Article 12 rights to a fair trial of the applicant, accused persons 3, 4, and 5 by proceeding with their plea on 5 and 6 December and entering pleas of not guilty on count 1 in the absence of their legal representatives, and in relation to applicant specifically, such pleas not being the plea he proffered on 8 December 2023. He averred that I engaged in unprocedural conduct, such as violation of the rights of accused 3 by refusing to hear his section 319 application, and of accused 4 by proceeding with plea taking in the absence of accused 4's lawyer, and refusing to take notice of the recusal application that accused 5 gave notice that he intends to bring. Based on the factual vehemence above, the applicant states in his concluding paragraphs that A, I have no regard to the accused's fair trial rights and principles requiring judicial officers not only to respect those rights, but also to protect them. B, my approach to his recusal, refusal to plead shows that I am, and I quote, determined at all costs to take the pleas of all accused persons irrespective of any possible prejudice. C, he entertains a reasonable apprehension that I am concerned only with completing the trial as soon as possible, irrespective of the accused person's rights, and that I will maintain that mindset throughout the trial. D, he is apprehensive that I have made up my mind in respect of the outcome of the trial, and at the very least in respect of the manner in which I will conduct the trial. E, a trial conducted by a judge such as me would constitute a violation of his rights in terms of Article 12(1) of the Constitution. F, when I was asked by his legal practitioner, and I quote, why there is such a rush in taking the plea while these constitutional issues to a fair trial are raised, I did not respond and totally ignored the issue. Based on these conclusions, he states, and I quote him, paragraph 15 of his founding affidavit, in the circumstances I have a reasonable apprehension of bias on the part of the judge and have no choice but to apply for his recusal. I am afraid that the impartiality of the court has been compromised, and I will not be afforded conspicuous impartiality. 16, therefore, I am afraid justice will not be seen to be done should the current judge continue to preside over my case, wherein I am facing serious charges as set out in the indictment. 17, lastly, it is required of a presiding judge to meru motu recuse himself or herself once it becomes apparent to them that they are biased. The failure by the presiding officer on this score is a misdirection. 18, in conclusion, I state that the court is itself conflicted, and it would be prejudicial to proceed with the further handling of my case, as it is clear that the court cannot be expected to adjudicate impartially due to the bias the presiding judge is perceived to have in the matter. I accordingly pray that it may please the court to grant the orders sought in the notice of motion to which the affidavit is attached. It is easily observable that four of the applicants' averments of fact relate more or entirely to accused persons 3, 4, and 5, and other accused persons not identified by the applicant. I pause to make a further a number of observations. Accused 3 was represented from the onset by Mr. Mrohora until he renounced agency by notice dated 4 December 2023, a day before the plea taking was to commence. Accused 3 was served with the application for recusal and did not do or say anything to associate himself with the application, even as he sat in the courtroom during the recusal hearing. He only rose to point out that he would be challenging the validity of my appointment, a matter he had written to the state president about. Accused 4 had indeed indicated an intention to apply for my recusal, as earlier stated, but has not pursued the matter to date. He was served with the applicant's recusal application and was present in court when the recusal application was heard. He did not at any point in time state that he associated himself with the application. Accused 5 is a client of applicant's legal practitioner and did not openly associate himself with the application. All the 9 co-accused individuals were in court when the recusal application was heard. They did not openly associate themselves with it. I cannot obviously take it away from the 9 accused persons that they were entitled to conduct themselves the way they did. For all one knows, they may have found it necessary to engage, they may have found it unnecessary to engage with the application in the belief that a favorable outcome would inure to their benefit as well. They may well have also believed that the application was not well grounded or sustainable in court. Mr. Marondeze submitted that the other accused persons were not parties to the application. And in respect of those legally represented, their legal representatives had stated in open court that they were there as observers and did not wish to argue the matter. In my view, the other accused persons are beyond, that is, the 9 accused persons are beyond any doubt interested persons, even if they have not directly made common cause with the applicant. The state filed an answering affidavit, which was deposed to by Mr. C.K. Utivezi. He is in the trial and in this application together with Mr. Marondeze. The answering affidavit starts off by examining the general principles of law on recusal. The deponent states that such examination assists in clarifying the state's contention that the application has no merit. I do not think that an answering affidavit should concern itself with issues of law to the extent exhibited therein. Its main purpose is to respond to the factual vehemence in the applicant's founding affidavit. In direct response to the applicant's vehemence, the state disputes that the applicant has made a case for my recusal. If the applicant was aggrieved by any refusal to postpone the matter at any stage, his remedy lay in an appeal and not in a recusal application. In regard to the allegation that I allowed Mr. Siomui to be absent from court on 5 December 2023, the state remarked that the state was not a party to that meeting. It went on to state that the applicant had no authority to speak in a representative capacity for any of the other accused persons, and for that reason, any reference to any of the accused persons in the affidavit will not be responded to. That he went on to say that although accused 4 may have expressed an intention to apply for my recusal, no application therefore had been served on the state. That the applicant's allegation that he was forced to plead was untrue. There was nothing unprocedural in what the court did on that score. The applicant's review application did not automatically put on hold the trial in the absence of an application to stay it and the issuance of an order for stay. That an adverse ruling against an accused person does not mean that Article 12 rights are automatically violated. In any event, the Criminal Procedure Act provides for a plea of not guilty to be entered on behalf of an accused who refuses to tender a plea when charges are put to him. In disputing the applicant's conclusions on the facts and the law, the state is this to say, and I quote, "It has not been shown how and in what manner it is being alleged that the Honorable Court has no regard for the rights of accused persons, and in what way those alleged rights have been violated. Once the trial is started, the correct procedure is to have all the accused enter their pleas. No prejudice, no prejudice that any of the accused stands to suffer has been shown. The suggestion that the Honorable Judge has already made up his mind about the outcome of the trial is not only mischievous, but an irresponsible statement that is completely out of order. Any reasonable person will never have an apprehension of bias on the part of the presiding judge. The applicant has dismally failed to prove or place on record any facts that may make any reasonable person even have the slightest imagination that any of the accused persons, applicant included, stands the risk of being subjected to an unfair trial. The applicant has adopted the wrong procedure, and therefore his application should fail." End of that quote. The applicant's written submissions, insofar as the factual argument is concerned, are no more than a word-for-word regurgitation of the founding affidavit. They recount what transpired on the dates set out in the founding affidavit, and on the basis thereof, the conclusion is reached that on those facts, as repeated in the heads, show that I am biased, and they provide a reasonable basis for an apprehension of bias on the part of the applicant. To the applicant's apparent credit, the years of argument refer to no less than 13 case authorities on the law on recusal. The state, however, accused the applicant's legal representative of plagiarism, where it states in its heads of argument that the applicant is uprooted paragraphs 9 to 11 of his heads verbatim from heads of argument that the state counsel previously filed in a matter of Ricardo Gustavo versus the state, without extending any case of acknowledging the work of state counsel. Thus, in the case authorities referred by the parties are the same. The state versus SH, in which are referred with approval the following cases. I don't repeat the citation, but the citation is in the judgment. S versus Munuma and others, Christian Metropolitan Life Namibia Retirement Annuity Fund and others, Lamek versus the state, President of the Republic of South Africa versus South Africa Rugby Football Union and others, and South African Commercial Catering and Allied Workers Union and others versus Ivan and Johnson Limited, Seafoods Division, fish processing. To my mind, the applicant's heads of argument fall short on applying the law to the facts. It is not enough to set out facts and then draw a bold conclusion that on the facts so outlined, a case has been proved. The first issue Mr. Marondeze raised before dealing with the merits of the application was the absence of Mr. Siomunji. He stated that Mr. Makondange did not know the charges that the applicant was facing. He did not know the facts upon which the application was based. He likened Mr. Makondange's situation to that of Mr. Siamunji's sister, a lawyer who, in S versus Scholar, performed a similar assignment on instruction from Mr. Siamunji, prompting the learned Judge Liebenberg J. to say the following, and I quote, "On the other hand, Ms. Siamunji, counsel for the applicant, did not advance an argument pertaining to the condonation application and submitted on a question by the court why the condonation application had not been addressed in the heads of argument, that the heads were drawn by her colleague for whom she merely stood in on the day of the hearing. She was thus invited by the court to make submissions on the issue. However, she indicated that she would stand by her heads and could not take the matter any further. Similarly, she also indicated that she had not read the respondent's heads and could therefore not reply to the respondent's submissions." And at paragraph 15, "Lastly, I deem it necessary," so said the judge, "to make a few remarks on the manner in which counsel for the applicant failed in his duty to provide his client, the applicant, with the quality of service he was deserving of and for which counsel would be remunerated by the Directorate of Legal Aid. Besides filing the heads of argument, which fell significantly short of addressing the issues at hand, Mr. Siomunji was not available on the day of the hearing and sent his colleague, Ms. Siomunji, instead with the instruction to abide by the heads filed with no need to make any submissions in furtherance of the grounds raised in the notice or otherwise. In fact, counsel was apparently merely required to show up and place herself on record. This is a serious dereliction of duty of an officer of the court and should not be left unsanctioned. The learned judge, with respect to the practitioner's dereliction of duty, ordered as a form of sanction that copies of his judgment be served on the Director of Legal Aid and the Director of the Law Society. A similar situation has arisen before me in this application. I consider that an appropriate sanction should be imposed even though Mr. Marondeze was cagey about it and did not want to be seen as leveling a complaint against a colleague, even though he was in fact doing exactly that. The state's heads of argument, on the other hand, canvass certain essentials of a successful application for recusal. They address the presumption of a judge's impartiality, which must be sufficiently dislodged or rebutted if the applicant is to succeed. They contend that the facts set out in the founding affidavit must meet the applicable legal principles, which in the state's view, the applicant has failed to do. That failure is spoken to by the fact that none of the applicant's co-accused have joined him in this application, including those on whose behalf applicant purports to speak. Applicant has rambled, so says the state, the applicant has rambled on about the right to a fair trial and the violation of his and accused 3, 4, and 5's rights, and that the presiding judge has no regard to the accused person's right to a fair trial. All this without showing how it is so. The recording of pleas of not guilty, where the accused persons refuse to plead to the charges put to them, does not constitute a procedural irregularity. The entry of a not guilty plea in those circumstances is permissible in terms of Section 109 of the Criminal Procedure Act. State Counsel goes on, in regard to the alleged violation of the accused person's constitutional right to a fair trial, the state submitted that the applicant did not lodge an application which would prove such violation, but is content to rely on unproved assertion that those rights have been violated. If I, as the presiding judge, so the argument went, were minded to deal with the applicant's contention that the right has been violated, the applicant is nonetheless not furnished facts and evidence of the nature of the violation. What applicant has tendered in the founding affidavit are conclusions of law with the primary facts on which they depend having been omitted. With reference to the case of Disciplinary Committee for Legal Practitioners versus Slisken, Makando and the Law Society, Slisken, Makando and versus Disciplinary Committee for Legal Practitioners and others, the state submitted that the applicant is required to prove an actual violation of the right and define the exact boundaries and content of the right, and that the right falls within that definition. On the authority of S versus Thomas Liebenberg, J, the dismissal of applications for postponement, which is the gravamen of the present application, cannot be a basis for a recusal application. Those were the state's submissions. The last issue that the state addressed in the written years of argument is the allegation that on 5 December, I proceeded with a plea taking in the absence of Mr. Siamunyi to the prejudice of the applicant and accused 5, when I had on the previous day granted Mr. Siamunyi leave of absence in chambers. The state submitted that the allegation is inadmissible hearsay. Mr. Siamunyi did not depose to an affidavit outlining the whole course of the discussion and the terms on which he was allowed to be away from court. In any event, counsel of accused 4 stood in for him during the rest of the day's proceedings. Insofar as the state is concerned, no factual basis has been laid in support of the assertion that the presiding judge is conflicted or that the applicant stands to be prejudiced by the judge's continued handling of the trial, and consequently, the recusal application must be dismissed. Mr. Marondeza amplified the state's written submissions orally and made a contention which I do not think he developed to its logical end for it to assist in my consideration of this application. Dealing with the reasonableness of the applicant's apprehension of bias, he submitted that the applicant is alone in pursuit of recusal. The persons whose rights applicant alleged were violated are here in court, and I quote him, are here in court and comfortable with the judge. They are not aggrieved and are not making common cause with the applicant, end of quote. I do not think that without further developing the point, Mr. Marondeza sought to advance, the reasonableness of applicant's apprehension of bias must necessarily be assessed against the stance of his co-accused, against the stance that his co-accused have adopted. As for conflict of interest alleged in the applicant's papers, no supporting facts were given. This needs no further consideration. Mr. Marondeza submitted that the reasonableness of applicant's apprehension of bias must be considered alongside the oath of office that a judge subscribes to. Where an applicant is aggrieved by a refusal to postpone a matter for any reason, the correct procedure is to adopt is to appeal against the refusal and not apply for recusal. In other respects, Ms. Marondeza repeated what is contained in the written heads. The intimation of a recusal, for example, the intimation of a recusal application by accused 4, which was not pursued, the section 109 of CPA permitting the entry of a plea of not guilty when an accused refuses to plead, and the absence of Mr. Siamunyi that is not backed up by his own affidavit when the state put in contention that issue in the answering affidavit. Follow now my discussion of the issues. The trial of the accused persons assigned to me is a matter of public interest, of grave public interest. Over the last 4 years, the accused persons have been denied bail and have remained in custody pending trial, except for the applicant who was admitted to bail after I became seized with the trial in late 2023. Over the period of time from their arrest and detention in 2019, it seems to me the accused have been legally represented in most, if not all, applications they made to the courts in connection with this matter, be it bail applications or Section 26 POCA applications, and in some cases representations to the Attorney General and Directorate of Legal Aid. Some of the accused have been granted illegal aid and others refused. The POCA applications do not appear to have been vigorously pursued. Those lodged in the courts are still pending determination. The accused were all legally represented when the matter came before me. The initial impression created, at least in my mind, and having regard to the in particular to the agreed timetable for the trial mentioned earlier, was that the way was clear for the trial to proceed. The main trial being a matter in which the public interest calls for reasonably speedy resolution, themselves no doubt being equally keen to have it finalized, I had to approach the matter in a manner that sought to serve the interests of the accused persons, the public interest, and the fair administration of justice. Equally important are the interests of accused 1, 7, 8, and 9, and the entities they represent, who have stated that they are ready to proceed with the trial. They will be prejudiced by any inordinate delay. These interests had to be put in the scales in determining the way to proceed in this matter. The main stumbling block to progress is the issue of legal representation. The accused person's assets are under a restraining order. They cannot access funds to pay their counsel of choice. The state is not budging on the restraining orders. One of the POCA applications spoken to by Mr. Mroora may, according to his estimation, be finalized in mid-2024. There cannot be any assurance that it will succeed. If it does not succeed, an appeal may be lodged and the application may take up to the end of 2024 to be finalized, again with no assurance that the accused will be successful. Legal practitioners who represented the accused until they renounced the agency, and those that are still representing some of the accused persons have indicated that they are not prepared to continue unless they are assured that their fees will be paid. In my observation, they seem to want to ensure that the trial does not proceed unless they have been put in funds. They also have not sought or shown an appetite to be paid at the scale applied by the legal directorate so that the trial could proceed. This is the situation that confronted me as presiding judge. To my mind, the situation begs the question whether, in the circumstances, the trial should not commence at all. After I settled on starting the trial by taking the pleas, the accused in effect sought postponement of the trial until they could secure funds to pay their legal representatives of choice. The legal practitioners present tagged along in the expectation that the accused would avail themselves of such funds. It was not lost to me that since the service of the indictment in 2021, the accused, as then represented, had discussed their responses to the charges with their legal representatives and were in a position to at least plead to the charges, thereby registering some progress. Regarding the applicant, he has always been clear, as stated in his affidavit, that he is not admitting the charges. In regard to him, therefore, a requirement that he should plead to the charges could not possibly prejudice him. He was even in the absence of his legal practitioner going to plead not guilty in any event. By extension of reasoning, neither would the other accused persons be prejudiced by taking a plea. Since the service of the indictment, no application is made to accept the charges or otherwise challenge them. No response to the state's pre-trial memorandum has been filed. When I made the order that the plea taking was to commence on 5 December, that decision was supportable by the situation that confronted the court. Thus, I refused to postpone the plea taking and indicated on several occasions that I would entertain any application from the accused persons after the formal commencement of the trial. I hoped then that by the time that evidence was to be adduced, the situation with respect to legal representation of all the accused persons would have resolved itself one way or the other. It was as a result of the refusal to postpone the plea taking that the applicant found cause to apply for my recusal. In a High Court judgment of Lesotho, High Court of Lesotho case, Motsamai versus Fako and two others, versus the DPP, on which AJ begins his judgment with the following statement. 4 things belong to a judge: to hear courteously, to answer wisely, to consider soberly, and to decide impartially. Every recusal application seeks to challenge this statement as it aims to demonstrate that as a matter of fact that the judge under scrutiny will not be impartial in the matter before him. I bear in mind, so said that judge, that I bear in mind what was stated in Moch versus Ned Travel Pty Limited, trading as American Express, namely that, and I quote, a judicial officer should not be unduly sensitive and ought not to regard an application for his recusal as a personal affront, end of quote. I find the learned judge's words to be opposite. I agree with the applicant's submission that impartiality and the perception thereof are fundamental tenets of a fair trial under Article 12 of the Constitution, and that the observance and protection of that right is paramount, is of paramount importance. This sentiment is echoed with erudition in the South African case S versus Lagrange and others, in which the court said, and I quote, a cornerstone of our legal system is the impartial adjudication of disputes which come before our courts and tribunals. What the law requires is not only that a judicial officer must conduct the trial open-mindedly, impartially, and fairly, but that such conduct must be manifest to all who are concerned in the trial and its outcome, especially the accused. The right to a fair trial is now entrenched in our Constitution. As far as criminal trials are concerned, the requirement of impartiality is guaranteed by Section 35(3) of the South African Constitution. Criminal trials have to be conducted in accordance with the notions of basic fairness and justice. The fairness of a trial would clearly be under threat if a court does not apply the law and assess the facts of the case impartially and without fear, favor, or prejudice. The requirement that justice must not only be done, but also be seen to be done, has been recognized as lying at the heart of the right to a fair trial. The right to a fair trial requires fairness to the accused as well as to the public as represented by the state. The statement I have quoted resonates well with us in this country because it applies with equal force to Article 12 of the Constitution. The applicant has imputed bias on my part. I need no persuasion that where the imputation is proved, a judicial officer must recuse himself. This is so because the perception of bias destroys the very foundation of a fair trial. Equally, as recently stated by Damaseb AJA in a Lesotho case, Platinum Credit versus versus Lerato, a judge has a duty to hear a case unless there are good reasons for not doing so. Where there is a real danger of a reasonable apprehension, a reasonable perception that a judge may not be impartial, there is a duty to recuse, including on honor code. Counsel for the applicant and for the state have both referred to President of South Africa and others versus South African Rugby Football Union and others. It has been cited, that case has been cited in many cases in this jurisdiction as noted by counsel in their heads of argument. That case lays down the test for bias in these terms, and I quote, the question whether a reasonable, objective, and informed person would, on the correct facts, reasonably apprehend that a judge has not or will not bring an impartial mind to bear on the adjudication of the case, that is, a mind open to persuasion by the evidence and the submissions of counsel. The reasonableness of the apprehension must be assessed in the light of the oath of office taken by judges to administer justice without fear or favor, and their ability to carry out that oath by reason. It must be assumed that they can disabuse their minds of any irrelevant personal beliefs or predispositions. They must take into account the fact that they have a duty to sit in any case in which they are not obliged to recuse themselves. At the same time, it must never be forgotten that an impartial judge is a fundamental prerequisite for a fair trial, and a judicial officer should not hesitate to recuse himself or herself if there are reasonable grounds on the part of a litigant for apprehending that the judicial officer, for whatever reasons, was not and will not be impartial, end of quote. The imputation of bias in this case arises from the events, as I have said, that occurred between 4 and 13 December, as outlined in the founding affidavit. The first allegation on carrying on with the proceedings in the absence of Mr. Siamonyi has not been proved. As argued by the state, the applicant was not in chambers, and when the purported leave of absence was granted to Mr. Siamonyi, and the full circumstances of the granting of that permission has not been disclosed. Mr. Siamonyi has not attested to the veracity of the allegation. The state disputed the applicant's version of events and pointed out that Mr. Bukas stood in for Mr. Siamonyi during the concerned proceedings. Applicant should have responded to the state's contention in a replying affidavit, which it failed to do. The allegation to me has not been proved and remains inadmissible hearsay without factual substantiation. The second allegation is that some of the other accused, and I quote, some of the other accused, asked for an opportunity to have their legal representatives present, and that I ignored them, and I pressed on and required them to plead. I ignored their protestations that their applications for funding had not yet been decided. I indicated that they had sufficient time to prepare for the trial, and I ignored the requests for postponement until they could secure funds for legal representation. In making these complaints, the words used severally are asked or requested in relation to what accused sought from the court, and not the word applied. Such use of words does not convince that they made an issue of the matters they were raising. It is insufficient, in my view, that in legal proceedings, to ask or to request for something and hope that so informally made requests should be responded to by a judicial presiding officer in the same way as a proper application. To make an issue of anything in the course of litigation, a person is expected to make a formal application verbally or in writing, and thereby constrain the presiding judicial officer to make a ruling. In the hearings I have conducted so far, I have been inundated with informal requests for better sitting arrangements, for better conveyance of prisoners to court, and for better facilities generally. Whilst I have responded to some of the requests, it has not been possible for me to meaningfully address others because of the informal nature in which they were presented to me. I had determined that the taking of pleas would have to go ahead, and so the request for a postponement would have had to be turned down. Where an application for a postponement is refused, the proper approach by an aggrieved litigant as submitted by the state is to appeal such decision in terms of the established procedures. Apart from the fact that the applicant was not entitled to take up the cudgels on behalf of the other accused persons, the refusal of a postponement without more cannot be a basis for an application for refusal. I find no merit in it as a basis for the recusal application. 4 issues are raised by the applicant with respect to the proceedings on 8 December 2023. I have outlined them. The alleged refusal by me to deal with the accused 3's application in terms of section 319 of CPA, and my statement that he could do so after plea taking. My refusal to postpone the taking of pleas when advised that Mr. Bukas was booked off sick until 22 December 2023. That I ignored and refused to entertain accused false intimation that he was going to apply for my recusal despite that Mr. Siamonyi had informed me as an officer of the court that it was imperative for me to hold the proceedings once notice of intention to apply for recusal has been given to me. And finally, that I forced the applicant to plead to count 1 when he had informed me that he had lodged an application for a recusal, for a review to quash the charges against him. The state did not respond substantively to the allegations relating to Section 319 of the CPA. It stands being that the applicant was not mandated to take up the issue on behalf of accused 3. Be that as it may, it should be said that a request for the reservation of a question of law in terms of Section 319 for the consideration of the Supreme Court is brought before the presiding judge, who, upon granting the request, shall, in terms of Section 317, subsection 4 of the CPA, state the question of law reserved. If the request is refused, the applicant has the right, in terms of Section 317, subsection 5 of the Criminal Procedure Act, to petition the Chief Justice for the question to be considered by the Supreme Court. I have already stated that when accused 3 raised the issue, I directed that he was at liberty to bring it up after the plea-taking exercise was completed. The question of law was obviously arising from the taking of pleas, and as far as I was concerned, there was no prejudice to be suffered by accused 3 if he brought up the same issue after pleading to the charges. The provision of the Criminal Procedure Act do not dictate that once a question of law arises, the proceedings must be halted. If accused 3 construed what I did to have been a refusal to state a question for the consideration of a higher court, his remedy lay in petitioning the Chief Justice as provided in the Act. The complaint arising from taking pleas in the absence of Mr. Bucas did not imperil his client, accused 4, in respect of his intended application for recusal, which he had threatened to make. Mr. Bucas was to be away until 22 December 2023, and accused 4, a former minister, was quite capable of pleading to the charges in his absence, having regard to the fairly long period during which they had been in consultation with each other. Therefore, he could not possibly have been prejudiced by tendering his plea. At the hearing of this application, Mr. Bucas was in court. If the proceedings on which the applicant based his application were substantially irregular, he would have made common cause with the applicant. As it turned out, applicant sought to take up the issue despite that Mr. Bucas was available to raise the same for his client. The above ground for my recusal is linked with the allegation that I ignored accused 4's intimation or notice as Mr. Siomunyo and applicant describes it, that he intended to apply for my recusal. Accused 4 was not entitled to think that if he threatened to file a recusal application, I was ipso facto obligated to stop the plea taking. An application had to be lodged first, then I would, as I did with the present application, consider halting the proceedings. What transpired in relation to this issue does not provide a reasonable basis for a recusal application. The last issue, which affects the applicant alone, is that I refused to stay the plea entry until a decision on the review application had been lodged, was made. Taking a plea in his case could not possibly have been prejudicial to him. From the outset, he was clear, as he says in his founding affidavit, that he was not guilty of the offenses charged. In his review application, which was not before me, if his review application, which was not before me, succeeded and the charges against him were quashed, he would no longer have had to appear before me on trial on those charges. Requiring him to plead did not detract from the review application in any way. Standing alone, I find this allegation to be an insufficient basis for a recusal application. The foregoing, what I've said above, the foregoing point in the direction that the factual allegations individually do not, in my view, constitute a basis for the applicant to entertain a reasonable apprehension of bias. I think, however, it would be unfair to the applicant not to consider the facts averred by him in relation to himself and in relation to his co-accused cumulatively. His general contention is that the taking of pleas in the circumstances of this case amounts to a violation of applicant's fair trial rights and those of his co-accused. This is summarized at the last bullet point of the founding affidavit, where he says, and I quote, "The presiding officer violated accused 3, 4, 5, and my Article 12 rights to a fair trial by choosing to proceed with the trial on 5 and 6 December 2023 in the absence of my legal counsel and entering a plea of not guilty to count 1, which is not a plea that I proffered to the court on 8 December 2023. The presiding officer also engaged in unprocedural conduct as he violated the rights of accused 3 by refusing to hear his Section 319 application and of accused 4 by proceeding with the taking of pleas in the absence of accused 4's lawyer, and by refusing to take notice of the recusal application that accused 5, and I think he must have meant accused 4, gave notice he intends to bring. To note is that it is erroneous for applicant to allege, as he does in the quoted portion of his affidavit, that a plea was entered twice on count 1 on 5 and 6 December and on 8 December. A plea on his behalf was entered only once on 8 December. Additionally, accused 3 and other unrepresented accused persons gave no indication of what steps they were actively taking to ensure that they obtained other alternative legal representation after Mr. Mrohora renounced agents, except that they hoped the Section 26 poker applications and approaches to the Attorney General would bear fruit at some indeterminate time in the future. Summarizing the case in the way he did, I understand the applicant to have in mind that I should look at what transpired in a holistic manner and consider the cumulative effect of the imputations and not look at each factor or imputation in isolation from the others. This is why he averts at paragraph 12 of the affidavit that what emerges from the foregoing, and I quote him, is that I have no regard to the fair trial rights of the accused and the principles that govern how judicial officers must not only respect those rights, but actively protect them. And that my approach to his refusal to plead showed that I was determined at all costs to take pleas of all accused persons, irrespective of any possible prejudice. In subsequent paragraphs, he avers that he reasonably apprehends that I was concerned only with completing the trial as soon as possible, and for that reason I would maintain that mindset throughout the trial, and that I have already made up my mind in respect of the outcome of the trial and the manner in which I would conduct it. It is undeniable, as stated earlier, that a perception of bias undermines the constitutionally guaranteed right to a fair trial. However, there is a significant hurdle that an applicant for recusal of a superior court judge must overcome in order to establish bias or a reason. It is the presumption that a judge of a superior court is impartial. That presumption is grounded in the nature of the judicial office and the oath of office taken by the judge, which impels such judge to discharge his office without fear and partiality. As held in the South African Rugby Football Union case, this presumption in favor of a judge's impartiality must be taken into account in deciding the question whether a reasonable litigant would entertain a reasonable apprehension that the judge was or might be biased. An applicant, such as in the present application, must therefore show that the conduct of the judge was of such a quality as to go beyond a genuine concern that in respect of a trial which should have long commenced and had not, the judge should now not take the first steps in that direction. Or to put it another way, was the conduct of the judge a pattern of conduct sufficient to discharge the presumption of impartiality and replace it with a reasonable apprehension of bias. In this regard, I refer to Lamek and others versus the state and to Bennett versus Absa Bank Limited, which are to the effect that both the person who apprehends bias and the apprehension itself must be reasonable, thus highlighting the fact that mere apprehensiveness on the part of the litigant, even if strongly held and honestly felt does not meet the required standard. On the facts of this case, it was necessary for the applicant to also set out in some detail that there was the possibility that I was inclined to the state, to the side of the state, that as he averred, I had made up my mind in respect of the outcome of the trial. This was necessary to dislodge an impression that the alleged apprehension was no more than a misapprehension of the duty of the judge to put the trial firmly on a formal footing by taking the first step of plea-taking. This is why in South African Commercial Catering and Allied Union case, the court cautioned against a failure by a presiding judge to be circumspect and not accept complaints of bias by disgruntled litigants. It is to be emphasized that not only is there a presumption of impartiality in favor of the court, but also that the presumption is not easily dislodged. Cogent and convincing evidence demonstrating conduct that gives rise to a reasonable apprehension of bias must be adduced. The court also cautioned that the court should not be circumspect, should be circumspect, not to permit a disgruntled litigant to complain of bias merely because a judge had made a ruling against him. In S versus Basson, the court said that remarks and adverse rulings in the course of pleadings, especially on points of law, cannot ground any acceptable complaint of bias. Damaseb DCJ in Lamech and others versus the state accepted the proposition that the circumstances of a litigant complaining of the conduct of a judge during the course of a trial differ materially from those of a litigant who relies on outside factors which he cannot judge on the strength of personal observation, and that the former kind of litigant must bring his complaint within the exceptions to the general rule. The applicant herein has failed to do so. The issue in this application revolves around my ruling that the accused persons plead to the charges. The High Court is a summary trial court. Such proceedings commence when an indictment is served on the accused and lodged with the registrar of the court, section 76(1) of the CPA. In terms of section 105 of the CPA, a trial proper commences when a charge is put to the accused by the prosecutor, and the accused is required by the court to plead to it forthwith. Section 109 of the CPA then provides that, and I quote, where an accused in a criminal proceeding refuses to plead to any charge, the court shall record a plea of not guilty on behalf of the accused, and the plea so recorded shall have the same effect as if it had been actually pleaded, end of quote. When some of the accused persons, including the applicant, were called upon to plead to respond to the charges by any, they refused to do so. In those circumstances, I entered a plea of not guilty for them. A plea of not guilty is entered for an accused person who refuses to plead, not only because section 109 of the CPA so provides, but also because the accused is presumed innocent until proven guilty. The justice system is not optional, and so an accused cannot avoid criminal liability or, without good cause, impede the progress of a trial by choosing not to participate or choosing to participate on his own terms. In Counsel, some of the accused wished to delay the plea entry because counsel who had represented them hitherto had withdrawn at the 11th hour, and they hoped that they would in due course access funds with which to hire counsel of choice, either through a relaxation of the restraint orders in place or through payment of their legal costs by the state, qua state, or by the legal directorate, Directorate of Legal Aid. In the case of the applicant, his main reason for refusing to enter a plea was that he had filed a review application, a review of the charges that he faced, and hoped that the charges would be set aside. I am satisfied that these reasons are not of themselves sufficient justification for a recusal application. The issue of legal representation was to be visited after plea as I humbly indicated. With all the accused are not in a position to say when the processes to resolve the issues they have raised will be completed. The request that the trial should not commence by plea entry entailed a postponement sine die. The question then arises whether in the circumstances I have set out, it was unreasonable to formally commence the trial by requiring the accused to plead to the charges. The question must be answered taking into account the position of at least 4 individual accused persons and the entities that they represent in the state who are ready to proceed with the trial. I think that requiring accused persons to plead to the charges in these circumstances is not unreasonable at all. I have already dealt with the issue of legal representation and indicated that in my view it is open to the accused and those who assist them to approach the court for a possible way of resolving their difficulty. I do not think that the accused person's stance in relation to legal representation should be construed as a stratagem to delay the trial indefinitely. Their cause cannot be saved by such a posture. I think the accused persons appreciate as much. The main issue is whether the double test requirement for recusal has been met. To meet the requirement that an apprehension of bias must be reasonable in the circumstances, the standard of a reasonable, objective, informed, and fair-minded person is used. In this case, the application cannot succeed unless the applicant has demonstrated that I have departed from the standard of even-handed justice or that there appeared the possibility that I might incline to the side of the state. It is the duty of the presiding judicial officer to ensure that the trial before me not only commences but progresses with reasonable promptitude. It is his duty to enter a plea of not guilty for an accused who refuses to plead. It is his duty to ensure that accused persons are afforded reasonable opportunity to arrange for legal practitioners of their choice to represent them. If a judge does something by which a reasonable litigant is led to believe that he will not receive an unbiased trial, the presiding judge should recuse himself, whether in fact he is biased or not. It is opposite to quote in extenso from the State versus SSH, where the Supreme Court said, and I quote, "The test of reasonable apprehension of bias was authoritatively stated in S versus Munoma and others. Stridom AJA at 1160 H2I clarified that the correct test is the reasonable suspicion test. The test for the recusal of a judge is whether a reasonable, objective, and informed person would, on the correct facts, reasonably apprehend the judge, that the judge has or will not bring an impartial mind to bear on the adjudication of the case. The reasonableness of the apprehension must be assessed in the light of the oath taken by judges to administer justice without fear or favor and their ability to carry out that oath by reason of their training and experience. An impartial judge is a fundamental prerequisite to a fair trial, and a judicial officer should recuse himself or herself if there are reasonable grounds on the part of the litigant the judicial officer was or will not be impartial. The position is the same in South Africa. The case of President of South Africa versus South Africa Rugby Union, the South African Commercial Catering and Allied Workers Union, and other cases. In the State versus S&H, the court continues, and I quoted paragraph 21, in order to justify a recusal, either at the instance of a litigant or the judge recusing himself or herself mero motu, it must be demonstrated that the apprehension is that of a reasonable person based on reasonable grounds. The presumption that the judge's impartiality, the presumption of a judge's impartiality is not easily dislodged and requires cogent or convincing evidence or reasons to rebut the presumption of judicial impartiality. A judge is a duty to hear a case unless the test of recusal is met. The making of a ruling or an order against a party, in this case, a refusal to postpone the plea taking when certain accused persons were not legally represented, or a refusal to await the outcome of a review application lodged by the applicant does not constitute a ground giving rise to a reasonable apprehension of bias. A reasonable person does not reach the conclusion that the judge will be biased or will take sides merely because he was in the interest of progressing the trial before him required accused persons who were legally represented just before the plea taking to enter their pleas. I consider that on any fair application of the principles of law I have set out above, the applicant has failed to make a case for his recusal. The application has no merit. It is accordingly dismissed. I have indicated earlier that Mr. Siomunji's conduct in this matter attracts a sanction. As was done in S versus Kohler, I also must sanction him for dereliction of duty. In my view, the appropriate sanction, which I hereby impose, is that Mr. Siomunji or Mr. Makondange shall not charge any fee for representing the applicant in this application. The Registrar of the High Court is directed to serve this order on the Director of Legal Aid and the Director of the Law Society of Namibia. That is my judgment.
May it please the court, your lordship, just in a response to the sanction that this court has imposed, for this court's benefit, no fees were charged to the applicant for this recusal application. It was done pro bono, so it is of no consequence. In that regard, your lordship, and this is with due respect, no fees were charged, it's pro bono. And in anticipation of the judgment of the court, of course, it's rightfully placed for this court to have pronounced its judgment, which we accept. Of course, we have to obtain the full judgment itself and study it, but my instructions are that we are going to seek for leave to appeal the judgment, and in terms of the Criminal Procedure Act 51 of 1977 as amended.
Just a minute, Mr. Munji, you're going a bit fast. The first point
Apologies.
the first point you made, just go slowly. The first point you made is that no fees charged.
No fees were charged to the applicant.
Yes.
May it please the court. Secondly, in anticipation of the ruling of this court, which of course could have gone either way in terms of the recusal application, my instructions are that, of course, we accept the court's ruling, but we don't agree with it. And in terms of the applicant, he is going to exercise his right in terms of Section 316 of the Criminal Procedure Act 51 of 1977 as amended, in that he's going to seek for leave to appeal to the Supreme Court. And in terms of Section 316 of the Criminal Procedure Act, he has 14 days in which to file a notice of leave to appeal. So we are giving notice that that will be done. Of course, we couldn't preempt the ruling of this court, but now that it has been handed down, that will be done. May it please the court.
14 days from the date that you get the judgment, isn't it?
It cannot be from, it means from tomorrow, Your Lordship.
I said from the date that you get the judgment. Is that not what the law provides?
Technically, yes, but technically the judgment has been handed, although the physical copy has not been given. And that's why I'm saying maybe from tomorrow, but technically it has been handed down. So we are anticipating.
Now, in terms of what law would you apply for leave to appeal?
Section 316 of the Criminal Procedure Act 51 of 1977.
Is that the law?
It is the law. My learned colleagues for the state can confirm that. And it states that, you know, a judgment of this court, of course, because we don't have an automatic right in criminal matters to appeal to the Supreme Court. So there has to be a leave to appeal, which has to be the notice of leave to appeal with the grounds indicated therein has to be filed within 14 days after the judgment.
Now, the question I'm about is whether in fact you need leave. That's the point I'm making.
Indeed so, Your Lordship. In our jurisdiction, for civil cases, we don't need leave. There's an automatic cases, we do need leave. That's why there's section 316 of the CPA.
Even in a case such as this for recusal.
Indeed so, Your Lordship. It's a judgment of the High Court.
There's a judgment of the Supreme Court. Tekla, Mandia, Lamek, and two others versus the state.
Your Lordship, that is the law. Even in a recusal application, one cannot just approach the Supreme Court automatically. There has to be a leave to appeal, and thereafter, depending on the circumstances, if the leave to appeal is dismissed, the other avenue is to petition the Chief Justice, and one has 21 days in order to do so.
Yeah, I'm talking about the 21 days and all that doesn't really matter. I'm talking about whether you need leave or not. Just that point only.
No, we need leave.
But I'm drawing your attention to the case I've mentioned.
Your Lordship, and that's why I also drew this court's attention to section 316.
Yeah, but this case dealt with section 306 of the CP&A. And it seems to me, it comes to the conclusion that if it is an application for leave, an application for recusal of a judge, and which has been refused, it's appealable.
Your Lordship, it is appealable, but the procedure is one has to still do a leave to appeal. And depending on the circumstances, for example, if Your Lordship...
Do you want to look at this case, mister? Because either I read it too quickly and didn't understand it. But my understanding of this case is that it says that a case such as this, a refusal to grant a recusal application, that is almost saying is appealable as of right.
No, Your Lordship.
Anyway, I don't think it's necessary for me to argue with counsel, but I was trying to help you. That if you might proceed, for those who can quickly access the case, you might proceed on a wrong footing. And I'm saying for those who can access the court, and I can even give you this one and tell me what it means. Paragraph 18 of the judgment.
And Your Lordship, and that is why I indicated that even my learned colleagues for the state...
Don't defer to them, defer to them, I'm dealing with you.
I'm
saying here is paragraph 18 of the judgment in Lamek versus the state.
Your Lordship, section 316 has not been amended or done away with.
I'm saying they interpreted section 316 in this judgment.
Indeed so, and that's why I'm saying, Your Lordship, and apart from just the reading of section 316, and in practice, any decision of the High Court has to go through a leave to appeal. And depending on, if Your Lordship is of the view that, well, let it go to the Supreme Court, then Your Lordship will grant leave. If Your Lordship is of the view that there is no merit to the leave to appeal, Your Lordship would dismiss it.
That's not my concern. My concern is this. You apply for leave when leave is not required. You see, time is unnecessarily wasted. If leave is required as a matter of law, you will be right to do that. But if leave is not required as a matter of law, then you will just be wasting time because the leave is not required. And I've drawn your attention, I think, Mr. Siomunji, you may want to have regard to that case. And then consider, because it did deal with section 316 of the CPA.
And Your Lordship, I am familiar with that case. And that is why I'm informing Your Lordship as procedurally, because, you know,
please, can you stop this habit of informing me? You lawyers make submissions. It's not like you're informing me. Lawyers make submissions. I submit. That's the proper language, I understand.
Your Lordship, it's semantics. Informing you in the court of law is through a submission. It is the same thing, but if your
You
lordship
can argue
wants
on,
me
but
to use the language
you
of,
can argue on, but I
submissions,
expect a lawyer to make submissions.
your lordship, we can argue over that, but for your lordship's convenience, if you want me to use the term submission, I'll use it. But for me, it's semantics, it's the same thing. Then my submissions that I'm making before this court are that in terms of section 316 of the CPA, I have to seek leave to appeal to the Supreme Court, and on that basis, I'm giving notice. And in 14 days, the notice of leave to appeal will be filed before this court. And then thereafter, hearing dates based on the notice of leave to appeal with the grounds will have to be determined. May it please the court.
Why are you not able to? Leave to appeal can be made at the handing down of the judgment, isn't it?
Your lordship, that would not be appropriate because, as your lordship indicated, the judgment, first of all, was very long. It has to be formatted.
Okay.
I cannot just anticipate, just from my hearing, I might have missed some points. As an officer of this court, I have to diligently go through the judgment and indicate the grounds of appeal, and that's when I'll be able to file them properly. May it please the court.
Does the state wish to say anything? Or before the court rises, what is to happen in the meantime?
Your lordship, what is to happen means, obviously, we've given notice. Because we didn't want to leave this court hanging or in a vacuum. We've given the notice, and we are anticipating maybe tomorrow or so, shortly thereafter, we'll receive the judgment itself after it has been formatted as we were informed. Within the 14 days, we will file our notice of leave to appeal with the grounds. And thereafter, once that is done, maybe we can already anticipate some date after the 14 days. We have to convene and agree on dates for the hearing of the notice of leave to appeal. Procedurally, that's what should happen.
What about if you change your mind?
Your lordship, I'm very clear on my instructions. There will be no change of mind.
You see, this is the point. What you call notice, unless you are making a formal notice now.
Your lordship,
that just let me finish. If I hope you are not merely telling me of an intention to apply for leave. This, what you have said to me, is an application or a notice, a formal notice that you will file the application for leave to appeal.
indeed so, your lordship. And it's the same manner that we made the notice for recusal. We gave notice and then we filed. But we cannot file, of course, now because that would be preempting or anticipating the judgment of this court, which we didn't know. But now that we know, that's why we are giving a formal notice that we will file a notice of leave to appeal with the grounds of appeal in terms of section 316.
Mm-hmm.
May it please the court.
Mr. State, or yes, sorry, and the unrepresented accused, just before you respond.
Yes, Judge, thank you for the opportunity. Judge, in this very case, there was an instance of a recusal brought, an application brought in respect of Judge Miller, Acting Justice Miller. And that matter ended up in the Supreme Court. Justice Miller did not grant the application for recusal. If my memory serves me correctly, leave notice of application, notice of leave to it was granted or not, but it ended up in the Supreme Court. In the Supreme Court, when that matter was heard, another issue confusing me, apart from the issue of leave, whether leave must be given or not, and unfortunately I do not have any for the Lamek case you were making reference to. The ones I have speak to summonses. Another issue that comes out in that leave is that we who had not intervened And in that intervention, the state had also not, until we intervened. When they then filed their papers, they had not served us. And the Supreme Court then made a ruling to say that you have to serve the other people. Now, going forward, I'm probably worried as to how we will be conducting this trial, in that the state can get away with not serving us, not even their notice of intention to oppose, or the papers themselves, and then it is taken as if we have taken a position. So in this very case, the law is seemingly my apologies, Judge. The judgment is being availed for me so that I could read from you from the paragraph. I couldn't find it on my laptop for one or the other reason. As I said, I'm not connected to the and maybe for the clarification, because I have to consider whether I would like to intervene in the appeal if one will be there, and how I continue in conducting. Do I only serve the state and Mr. Siomunji on behalf of the applicant, or do I also serve everybody else? My understanding was that just because somebody has not filed per se doesn't make them still a party of interest. Sorry. In that judgment, in the Supreme Court, it's case number P 15 of 2022. The parties are James Nependa Hatwikulipi and others and Ricardo Gustavo in re, the petition for leave to appeal by Ricardo Jorge Gustavo. Paragraph 16 thereof, 16 to 19. This is what it says. Condemnation application. The intervention application was lodged with this court and served on the state on September 26.
Mr. Shangara,
Yes.
what is the point you are making? What is the point you are making?
Well, Judge, having given the citation, I'm pretty sure that it may be available. I've made the point. The point is this, that in this very case, there was a recusal before. There was a procedure followed. It seems to me that this procedure is different.
You agree with Mr. Simoni?
I was under the belief that that was correct.
You agree with Mr. Simoni's submissions?
Yes, and I was under the belief that his position was correct.
Yeah, he may be correct. I was drawing his attention to some case, which I think is to the other. It says
Yes.
something different.
Yes, and the second, yes, I'm fully aware of that. That's why I'm raising the issue to say that we now have, in one case, two different ways it was dealt with. And when it was dealt with in the Supreme Court, another issue comes out, that when the state fails to give notice to litigants in this matter, it's an issue. But now it seems in this court, although the Supreme Court rules differently, that it means that it's approval and contentment with the situation, as it were, which is not the case. So I'm just raising the issue that I'm finding myself a bit confused and seek the court's clarity going forward on this issue, on these two issues.
Anything else from any of the unrepresented accused? Right, Mr. Yes, Mr. 'Mr. 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 '
the state can only wait to be saved with the papers, my lord.
My question,
And,
we are
and
talking about,
respond
I
accordingly.
was trying to invite you to make a comment on the question of law. which
Okay,
I-
on the question of law, my lord, that point, my lord, I don't need to, I've always guarded against giving legal advice to legal practitioners, but I will do so, my lord. The judgment of Tekla Lamek and others, I've read it before, I don't have it with me now. The point was, the state had raised points in Limine that there cannot be no appeal against the refusal of a judge to recuse himself, because in terms of section 316, an appeal can only be made after sentence. That was the point which was being addressed in Tekla Lamek in paragraph 18 as the judge says. Then the court says no, that judgment is appealable, because the state was saying, relying on Malumo case, in that case was saying that only in exceptional circumstances can leave to appeal be granted against a refusal of a judge to recuse himself. So there should be an application for leave to appeal. Personally, I've held, I was involved in the matter of state of SNH. We filed an application for leave to appeal, which was refused by the court, the Kotako. Then we went to Supreme Court. Then we have the matter of state versus Steve, matters of Steve, where the magistrates had made him to recuse themselves. We were involved. We filed an application for leave to appeal to the Supreme Court, which leave to appeal was granted by the court, by the High Court. There was no need to petition. So, my lord, on the point of law, application for leave is required.
And where does that take us now?
My lord, Mr. Simunje was right in his computation of dates, but I will urge him not to wait until the 14th day to file the application for leave to appeal, so that we deal with this matter as quickly as possible and not wait for 21 days. He should.
I'm going to urge him or persuade him.
If this court is persuaded that there are grounds indeed, which I doubt.
No, I'm saying, are you going to persuade him to file earlier? Because what he says is it's within his rights, and you are saying I urge him. I thought you would say
I'll talk to him off record, my lord.
Right.
I'll talk to him off record. Because I don't have powers to compel him to do that, but I can only plead with him off record that he does this as quickly as possible, so that we try and not waste as much time as possible. Yes, indeed, he has 14 days to file the application for leave to appeal, and then the matter can be set down following the necessary procedures of filing of heads of arguments by the parties, my lord. But I can assure the court that the state will oppose that application strenuously. And
if you are going to oppose, it doesn't matter whether strenuously or...
it matters, my lord, because there are no grounds, really, from the judgment.
Right. Anyway, look, the parties have my judgment. I was only asking this question so that we see the way forward. And it seems to me that both parties are saying, the state and Mr. Simunji are both saying nothing will happen at least within the next 14 days or thereafter. That is to say, in your understanding of the position, we cannot proceed until the application for leave to appeal has been filed.
What I know, my lord, is that only on the authority of matter of state versus Thomas, only after the application for leave to be heard, for leave to appeal against the recusal of the judge was refused, the court ordered that the trial should proceed only after hearing the application for leave. But before that, the court waited for the leave to be had.
But wouldn't it be even more serious then?
No,
That
but
after,
they petitioned the Supreme Court, they failed.
After the petition to the Supreme Court has failed.
Yes, they failed.
And the petition is filed in what circumstances?
The court refused the application for leave to appeal. Then, during the time the accused person was petitioning the Supreme Court, the court made an order that the trial must proceed.
Yeah, but what I'm saying, what is the procedure where the judge grants leave?
If the judge grants leave, then we have to wait, my lord, until the Supreme Court hears the matter, because the judge will be seeing the prospects of success that the applicant might likely to succeed in having the judge replaced. So it would be a futile exercise to proceed with the trial where leave is granted by the presiding judge.
So, in your view, and I'll invite other interested persons, what do you think is the way forward? 14 days come, application for leave is filed, then we proceed with that.
That's correct, my lord.
Yeah, I kind of liked the distinction you made about the Tegla-Lamek case, because the impression one gets on a quick reading of it is that where it comes to recusal, because the recusal is equated to jurisdiction. The court said in that event, that's my quick reading of it, I looked at it before I came in. In that event, it's akin to jurisdiction. And in that event, there's no need for leave to appeal. But you are saying, both of you are saying, leave is required. I'm not, of course, I'm not seized with that matter now. But I would urge you to look at that case.
Yeah, that's correct, my lord. In the Tegla-Lamek, that issue did not arise for decision whether the accused can appeal as a matter of right. The question was, the state was saying, you can't appeal because the only way you can appeal to the Supreme Court is through Section 316. And 316 says you can only appeal after sentence. That was the point which was debatable, then whether they can appeal against the recusal. And that's the point which the court decided there.
I hope you're correct.
I'm very correct, my lord. I'm very correct there on that point.
All right.
Thank you, my lord.
So, what order should I issue now? Is there a need for any other order apart from the orders?
My lord, now the only issue is to remand the matter to a day after 14 days. 14 days are counted in terms of the Criminal Procedure Act. 14 days after the judgment has been handed down, the written judgment has been handed down to the parties, not today, my lord.
Yeah, that I agree.
Yes. 14 weekdays, Monday, Tuesday, Wednesday, Thursday, Friday, Saturday, Sunday, are counted in terms of criminal procedure. So can we have the matter postponed to at least a period after 14 days? I don't know when the written judgment will be.
You got the diary.
I don't know when the
written judgment, I'm not sure what I just heard that they format the judgment, isn't it? So that I don't know how long it takes, but I don't think it will take them more than a day or two.
From my rudimentary knowledge of IT, my lord, formatting is not a problem. It's just aligning the paragraphs. So it's not something that will take an hour to do so, my lord. So I hope that it will be available tomorrow. Tomorrow is the 13th of March.
Now let's give them some leeway, maybe 2 days.
Okay.
Yeah.
Let's say it will be available. Let's start counting from the 18th, which is Monday, my lord. The 18th of March. So 2, 3, 4, 5, 6, 7, 8, 9, 10. The 14 days ends on the 31st of March, which is a Sunday. So we can postpone the matter to the 1st of April. It's a holiday then. It's Easter. It's
Fool's
Easter.
Day.
It's Fool's Day as well. We can't. It takes away the seriousness of the matter if we postpone it to that date. We can have the matter postponed to the 2nd of April, my lord.
Mr. Simui.
Please the court. Your Lordship, if we may have the matter postponed to the 3rd, the reason is on the 2nd, I'm inundated with another matter concerning law society and another and a client of mine. So there's a hearing on that day before Judge Klassen. So if I may humbly ask that we have that on the 3rd, that would suit me fine. I don't know whether that is amendable to all the other parties, but the 3rd is fine.
3rd of April.
Yes, Your Lordship. However, I think there is one thing we overlooked, because the 14 days is days in which to file the notice. So come maybe on the 3rd, Your Lordship should be able to direct us to file our heads, which in terms of the practice directives is 15 and 10 days. 15 days before the hearing, that is for
the date we are concerned with, as far as the state is concerned, it's some kind of a date to remand the matter, isn't it?
Yes, then that would work for the 3rd. So it
in
can
terms of that application, it has got its own rules, isn't it? In terms of the TS in Dukia.
Yes, Your Lordship. So on the 3rd, the court will be able to determine when the parties should file their heads, which according to practice directives is 15 and 10 days. So 15.
Yeah, that will come to it. All we want to know, that will come to it when we cross.
Indeed, so Your Lordship.
Because on the 3rd, we will know that you have actually filed something. You know what
Indeed
I'm
so.
saying?
Indeed
And that
so,
is why the state is saying, let's adjourn the matter to that date.
That is in order, Your Lordship.
All right. So is there anyone with a difficulty about the 3rd of April? Mr. Engelbrecht.
If the court pleases. I've listened to all the parties. As far as the date is concerned, I would be out of town, but it's just for basically a date for the interested parties in order to get dates in when to argue the matter and when to file it. So I don't foresee any reason for the 3rd of April. I would make necessary arrangements for one of my colleagues just to stand in for me, as the court pleases.
Yes. Any of the unrepresented accused with any difficulty with that? None. Okay. So, I will, Mr. You obviously have no difficulty with that.
The state has no objection, my lord.
Right. So, by consent, the matter is postponed to the 3rd of April, and the usual orders in regard to the remand of the accused persons issue.
As the court pleases.
Court adjourns.